ఇవాళ మీ కొలీగ్స్ అందరూ కలిపి
Good evening, one and all. People are joining. We will wait another 2 minutes.
Progress.
May I start, sir? Round.
చేయండి. అన్మ్యూట్ చేయండి. అన్మ్యూట్ చేయాలి.
మీరు ఎక్కడున్నారు అసలు? A small adjustment. Namaste, one and all. Good evening to one and all. And I welcome you all to the EGNA Legal live lecture series. And let me introduce ourselves. We group of advocates, we form as a law firm to practice, and as a part of social responsibility, we have been conducting webinars since last 3 years, and hope this will help to all the advocates of AP and Telangana who can communicate Telugu as well as English. That's why usually our programs will be in both English and Telugu. And in the part of the same, we wanted to have lectures on newly new acts, whereas our today's speaker pleased to accept teach us or give his lecture on in the and that new act on enlighten us on new acts. Now I request my colleague Sri Haribabu Garu to introduce today's speaker to all of you.
I feel it as a privilege to introduce Mr. Dittakavi Ramchand Garu. Sri Dittakavi Ramchand Garu is a law graduate from Madras Law College, and he studied and he completed his law from 1976 to 1979, and he enrolled in the AP Bar Council at Hyderabad in the year 1980. He has put up his distinguished career of 44 years. He set up his practice initially at Gudivada and often used to attend district and sessions court at Machilipatnam. Later, he shifted his practice from Gudivada to Vijayawada in the year 2008. And since he is practicing at Vijayawada and other Mafsil courts, he practices on criminal side and has appeared in good number of sessions cases in sessions court and other criminal cases in magistrate courts also. He is still active in practice. Of course, వారు మనిషి పెద్దగా కనిపిస్తున్నారు కానీ ప్రాక్టీస్ లో గాను మాట్లాడే విధానంలో చాలా యాక్టివ్ గా ఉంటారు. He came from a reputed family of advocates, since his grandfather, late Sri Dittakavi Satyanarayana Garu, was also a reputed and famous criminal lawyer who retired from service in the year 1972. Sri Ramchand's father, late Dittakavi Vishnumurthy Garu, was also a well-known and famous criminal lawyer who had the reputation of criminal court lawyer in sessions cases. He is always fond of discussing different aspects of criminal law with his colleagues and junior members in the bar. And the same concept was carried, and in the changed social scenario, the same concept was adapted through webinar, that is by using this Zoom. His own brother, who recently passed away, was also and also his sister Lakshmi Kumari and brother-in-law Satyanarayana Murthy Garu are all practicing advocates, and we definitely gain not in words of గెయిన్ అంటే గెయిన్ అనే వర్డ్ వాడకుండా వారి నుంచి మనం చాలా పొందడానికి అవకాశం ఉంది. వారి నుంచి మనం మంచి ఈ లెక్చర్ మంచిగా ఆశిస్తూ అందరూ లాభపడతారని ఆశిస్తూ థ్యాంక్ యూ అనండి.
And today's the concept of today's lecture, it will run for 6 days, and I have specifically given you the scheme of the program schedule, and you please observe that schedule. And every day the class will be at 8 o'clock, and కొంచెం లేట్ అయింది సార్. And on 30th it won't be there. Please observe the same. And I welcome you, sir. Today's subject is introduction and the basic principles of crime. The podium is yours, sir. Please carry on, sir.
Thank you very much, madam. Pretty good evening to all the friends who are enthusiastically joining this session. Friends, the anxiety in one and all is that there is a new penal law in the name of Bharatiya Nyaya Sanhita 2023 is brought in by the present government. And what are all, the anxiety is that it's a new act and one must learn from what are the new provisions introduced in it. Before going into it, just I want to tell to those who are not connected with this criminal side of the practice or who are new to the criminal practice. Criminal law is both easy as well as tough. Feeling tough if you leave it, when the occasions come, we will be in a confused and problematic condition. So to know something of the matter is always good. You should make a beginning at one point of time in the life, in the professional life. As it is said in many circumstances, a 1,000-mile journey starts with the first step. So to those of you who are very new to this subject, I welcome and try to just understand the basics first and sharpen yourself by studying regularly and day by day improving your knowledge. It can't be, as you all know, law can't be learnt in a single day or in a single year. New judgments will be coming, new interpretations will take place, that we all know. But the basic subject will never change. So my sincere request to all of my friends here is just have some strong footing and understanding of the basic principles of the criminal law first. Today I want to cover that aspect. This Bharatiya Nyaya Samhita 2023 is about to be repealed completely from July 1st of this year, as you all know. And my first request to one and all is, don't have the idea or any, say, confusion that a totally new act is coming and falling on our head. That can be easily understood. As the days goes by, you will understand what I mean today. Sir, actually, when we want to understand the particular subject in any subject in the law, what we have to understand is the legal terminology. The terminology is peculiar to one field to other. Criminal law has got its own terminology. That terminology you must imbibe and you must cultivate. That is my first suggestion to one and all who are new to the subject. Those who are already having some experience, I need not tell this. But the other thing is, generally, some ideas will be there. Those ideas have to be transformed into the particular places in the subject, and we have to sharpen our skills. For that, I first want to introduce you to two terms. Terminology, in the sense terminology. There are two words we use regularly: crime and offense. Sir, are the two one and the same? Please think over. Crime and offense are not one and the same, sir. Have this clearly in your mind. Crime is a general term. Crime is a general term and offense is a specific term. Save Save Okay, thank you. Sir, crime is a general term. Any untoward incident or untoward act by another person, we call it as a crime. We may call it as a crime. An unwanted act by one person against us or against another person, we call it as a crime. It is not always an offense. Please understand this. I give you, generally crimes are of three types. The number of these acts fall into three types, sir. One is social crimes. The other is political misdeeds. And the third is punishable crimes. Social crimes are many. Just to give an example of that, I go out with my friends and there I enjoy the evening with my friends, lavishly spending something from my own pocket. I have good currency in my pocket, and there is a person who is in need of money who is not known to me, say a beggar. He comes and begs with me, sir, I am not having food for the last 3 days. I am unable to even stand. Please give me something to eat so that I can purchase and eat. I simply brush him aside, get out of the way, and then get into my costly car and run and go away from that with pride and all those things, ego, like etc., etc. I have made him to starve further. Suppose he dies a few hours later. Is it a crime on my part? Just think it over. No doubt it is a crime. But to what result? Nothing. He dies, I go to my home and I do my own things. Sir, this is my act is an immoral act, a sinful act maybe. But no action can be taken against me because there is no law which can take some action against me and punish me or in any way impose penalty upon me. These are only, sir, social crimes. Similar crimes, you can imagine several things. Coming to the second category, which I just said, political misdeeds. Elections come, sir. I contest as a candidate for one party or individually, whatever it is. On the stage in every area, I promise heaven to the voters. In every house, I will give employment to everybody, and I will see that food is supplied free of cost. Like this, I gave several promises. And people who are innocent vote me in large numbers, and I win the election with a large majority, a record majority. After entering the assembly or so, and my government is formed, I forget everything. I don't even visit my constituency later. Can you take action against me as cheating the public? Everybody knows we can't do anything. Next time, they may defeat me, even without giving me a deposit required votes. So these two types, first thing which I said about social crime beggar incident, and the second thing are not at all actionable wrongs in criminal law. No action can be taken against these two types of faulty people. The third thing is there, punishable crimes. Those are exactly the subject under the Bharatiya Nyaya Sanhita 2023 as well as Indian Penal Code 1860. So this distinction is there. First, we must understand this specific thing. Unless a statute prescribes a particular act committed by X, Y, or Z as a punishable act or an act which involves or invites punishment, it is known as a penal offense. That is exactly what is required for our study. Unless and until the legislatures enact a particular act for eradicating that evil in the society, nobody can do anything. The best example, if you can recollect, the dowry death cases are there. Until section 304B is enacted by Parliament, 304B IPC, several deaths of number of women, housewives went unpunished. So the society brought pressure on the Parliament, and the Parliament has brought in section 304B, which is a punishable act, dowry death. Like that, what we have to understand here is, any act to be punishable, it must be an offense under one enactment or the other. This is very specific, sir. That is why in the beginning I told you that crime is a general term, offense is a specific term. Actually, while dealing with the various offenses under this Bharatiya Nyaya Sanhita or Indian Penal Code 1860, to call them as crimes is not a complete terminology of it and a complete understanding of the matter. For this, I request one and all of you to just refer to the preamble of Bharatiya Nyaya Sanhita 2023. It is very specifically worded there, sir. Just I read. An act to consolidate and amend the provisions relating to offences. They did not say crimes. An act to consolidate and amend the provisions relating to offences and for matters connected therewith or incidental thereto. So, this act refers only not to crimes. It refers to offences only, or it deals with offences only. So, as a criminal lawyer, we must use the terminology as offense, not as a crime. Generally, we say crimes are on the rise, crime rate is running high, like these things. Those are all general terms for statistical purposes. But when we are concentrating on the subject and talking particularly in a subject matter, you should refer to as penal offense. It is not a crime. Crime is with respect to the society, not to the legal subject of the matter. Just this is to clear certain things, sir. I am bringing this to you. And to take the matter, to just take the seriousness out of the matter, I want to, every one of you, just to see one coincidence in both the Bharatiya Nyaya Sanhita 2023 and Indian Penal Code 1860. Both are strangely Act number 45 of that year. Bharatiya Nyaya Sanhita is Act number 45 of 2023. Indian Penal Code is Act number 45 of 1860. This is a strange coincidence, not much a point to think over it or remember it. Then, sir, next. What is an offense is a question. I request every newcomer to this subject or a new entrant into the field. I sincerely request to understand one thing. Have clarity in the subject to the extent that is possible. Without clarity, we can't gain any knowledge in the subject. So clarity of thought is the important aspect, and particularly criminal law has got its own terminology and its own application, which is peculiar to it itself. Other enactments in the civil law or in the constitutional law don't have this type of terminology. They have different terminology, that is a different aspect. My next thing is, what is an offense? That is again has to be clarified. Just general theory, I have just told you. Then what is an offense? Is it there anywhere defined or indicated? Or you have to read all the sections to know the term the offense? There is actually section 2, item number 24. If you have got the Nyaya Sanhita, please see this. The first 3 lines are sufficient, sir, to understand this. Except in the chapters and sections mentioned in subclass A and B, the word offense means a thing made punishable by the Samhita. This definition, sir, whatever is punishable or whichever act is punishable under the Samhita, that is an offense. Whichever is not punishable, which I said about the beggar's case and the political speeches, promises, etc., they are not offenses. So, for a thing to be made to be designated as offense or described as an offense, one should search for a provision in this penal provision, punishable provision in this act. The same definition is there, sir, in IPC, which is equivalent to section 40 of the IPC. There is not much of a difference between these two. There also the same terminology is used, a thing made punishable. I think I am making myself clear while saying about this. Sir, for more clarity, I request one and all to refer to the judgment of the Honorable Supreme Court reported in 2006, Part 2, SCC Criminal, page 221, in para number 29. This judgment is not actually given under the IPC. It is under the Foreign Exchange Regulation Act 1973. But there, their lordships clearly described what is offense, and in so many clear terms. An offense only means the commission of an act contrary to or forbidden by law. So the act which the fellow has committed must have been forbidden by law or it is contrary to law. That is the meaning of the term offense. Then it is not confined to crime alone. The Honorable Supreme Court clearly said there, laid down in the decision, the term offense is not confined to crime alone, because crime is a vast meaning word. Its application is pervading into different fields. So that is why in the definition also, that thing which is punishable by the Samhita is only an offense. Further, the Honorable Supreme Court had clarified this. It is an act committed against law or omitted, because act includes omission also, where there is a duty to act. If the person omits to act, that is also an offense. So it is an act committed against law or omitted where the law requires it and punishable by it. In its legal significance, an offense is a transgression of law, a breach of the laws established for the protection of the public, as distinguished from an infringement of mere private rights, a punishable violation of law, a crime, the doing that which a penal law forbids to be done or omitting to do what it commands. The expression offense as defined in section 3, item number 38 of the General Clauses Act also, it says that an act or omission needs punishable by any law for the time being in force is an offense. because wherever there is a doubt, we refer to General Clauses Act. There also a similar definition is given. So, sir, what now in this decision, clearly their lordships have held that private rights are different. For this, as you all know, I take, say, some 25,000 rupees for my necessity from one of you and execute a pro note. After a couple of months, I promised to give it, but later on I don't give it. Some months pass, you start demanding it. Then I said, you do whatever you like, now I don't pay. Then the fellow says, sir, you have promised to give, and whenever I ask it, now you are talking like this. What? I don't give, do whatever you like. These are naturally every day we come across. Is it not cheating, sir? That is why it may be a crime, but it is not an offense, because cheating has got its own definition. Illustration G, if you can see under section 415, they say, at the time of taking the item or entering into that contract, if the fellow had got the intention not to pay, just for taking that property from him, that movable property, something like that, without having any intention to pay it back, that is cheating. Otherwise, all other transactions are only broken promises. So, offense, that is why the lordships in this decision which I have just read over say mere private rights are not offenses under the penal law. Otherwise, all the civil lawyers will not have any practice. Every broken pro note will come to the criminal court only. Is it not? Because the definitions of offense is very important. What is an offense in a particular situation has to be clearly understood. We have to bring the act into the four corners of the definition. That is why the term offense is specifically described like this and confined by the enactments like this. Here actually, one thing I want to tell you, we are only studying this Bharatiya Nyaya Sanhita in these few days. There are other penal laws also, say Prevention of Corruption Act or Excise Act. These are also punishable acts, offenses. We are in this act, this is a general law, and those acts are special acts. Those types of acts are override the definitions or anything mentioned herein in this are incorporated in this act. So one fundamental principle, as you all know, special law overrides general law. So action has to be taken under the special law only. And alternatively, they may add these sections also. If that fails, just at least the case may stand in this. With that hope, they may charge sheet in that matter. That is different aspect. So, sir, now, having said so much, what is an offense? Can we understand by the simple definition, the thing made punishable? Is it sufficient? Start. So, sir, so what is an offense? Actually, in criminal law, we come across human behavior, if you can see it in a different, from a different aspect. How people react, how individuals react to situations, whether they will be accepted by the society and whether the law accepts them or prohibits them is the question. All the aberrations of the human mind are there in this term offense. That has to be understood. because we are now talking on the foundations of the criminal law. Criminal law is not enacted on a single day. Lord Macaulay did not bring IPC on a single day. There was a long evolution of law in Britain, developed as common law. And those principles, some of them, they have incorporated in IPC for application in India, as you all know. Likewise, certain other developments have taken place in that the definition of the offense also is there. We have to understand going into the theory part of it. This will not be there in the IPC or in the Bharatiya Nyaya Sanhita. Actually, offense has different stages. First, the offender entertains a motive to commit the offense or to commit the act, forbidden act. Motive is the triggering point for him, or that which prompts him to do that act. Motive is not punishable at all, sir, as you all know. Motive is only one thing which the prosecution or the complaint stands on. And then he forms an idea in his mind to do an act with a purpose. And how to do it? All these things, before that, he forms that idea. That is the guilty mind, which they call it in common law as mens rea. Here, with due respect to all, some of my friends call this as mensi rea. It is not mensi, sir. MENSREA, mens rea. So, don't spell it as mensi rea. It is only mens rea. That is a Latin term, it appears, that is borrowed by the common law. And its spirit is brought into Indian Penal Code as well as this Bharatiya Nyaya Sanhita. So one must understand this mens rea, which is the guilty mind part of the act committed by the offender. Unless you have got specific understanding of this mens rea, our knowledge on the criminal law or the penal law will not be full. There will be some deficiency. Why? I just give an example in a few minutes time. Because a motive is there, first entertained by the offender. Say, I am entertaining an idea that my neighbors are very rich and I am just an average man having not many properties, have not many luxuries which I can involve in. So, suppose I am a bank employee, being a cashier, and have got dealing with the cash every day. My job is to disburse the cash, or if somebody brings it, I have to deposit it in the bank. I remember my level of poverty or lack of property in myself. So I take away from the bank a couple of lakhs of rupees or a large amount. In order to take it away, first my poverty is the motive which drives me to look into that cash notes and take an opportunity. Here, my guilty mind is taking shape to swindle that money from the bank without the bank's permission. Then I commit theft of it, or I misappropriate it in some manner and get that gain for myself, which is punishable under law. So here, what they are punishing, what the act is punishing is, or what the Nyaya Samhita or penal code is punishing is that mind aspect. First, without that mind, there will be no offense. So, mens rea or the guilty mind aspect of the act is the most important thing. It is the heart of the criminal law. If you take some patients, I will give you another example. Excuse me if I'm exceeding my limits. I find a woman just a couple of flats away, and seeing her, I want to have some immoral or sexual connection with her. This is my motive. With that motive, my motive is to have that connection. Then I decide one day that by hook or crook, I should approach her and fulfill my lust. If she consents, okay. Even if she doesn't consent, I want to fulfill it. That is the guilty mind. Then the act will be committed. That is why, as you all know, in these sexual relationships and in these offenses, if there is consent on the part of the woman, no offense. Because this man's mind cannot be a guilty mind there. So, sir, with these types, there will be many examples like this. What I request one and all is to just have some clarified thought on this. Have clarity of thought that this mental aspect of the offender is very, very important. That is why in several decisions, it is said by the lordships or laid down by the lordships that guilty mind is the actual mental state of the person at the time of committing the act. That is the guilty mind part. And with this guilty mind, the next stage of the offense is preparation. So, sir, first a motive has started in my mind. I entertained a motive. Then a guilty mind formed in my mind. Then I start preparing to do the next stage or to enter into the act, committing the act. Up to this stage, even for preparation, in most of the cases, sir, law doesn't punish. Because after preparing, before going to commit the act, I may change my mind, idea, and return back. At the time of putting my hand on the cash in the bank, I may say somebody may catch me. Why should I? We will see another way, another say event, and I leave that. So I have prepared also, but did not commit the act. There is no law which punishes us. So motive, mere guilty mind, and preparation are not punishable. Then, sir, but there are some offenses. Preparation is also punishable. Those are specific offenses. As you all know, Section 149, 150, in 150 and 310, subsections 4, 5, and 6 of the Bharatiya Nyaya Sanhita. Sir, I repeat, 149, 150, 310, 4, 5, and 6 subsections. These are preparations that are punishable. They are equal to 122, 123, 399, 402, and 401 of the IPC, respectively. These are acts preparing to commit, preparing to wage war against the government, to topple the government, accumulating arms, or preparing a group. I want to wage war and topple this government. That preparation itself is made punishable. Preparing to commit dacoity. Dacoits come from somewhere and take a room in this town or city, and they will be coolly staying in the daytime, but their antecedents and other things, the police get the idea and then catch them. If they can prove that these people have taken the room for preparing to commit or in course of the preparation of committing dacoity, because they should know the graph of this map of this city, which house is convenient, all these things. So this preparation is made punishable there. Belonging to the gang of dacoits was also made punishable, though dacoity was not even attempted or committed. So in these specific instances only, preparation is also made punishable. Then the next thing is, sir, why law doesn't make the preparation punishable? There is a chance for the offender to change his mind, thought over it, and once for all withdraw from doing that act. Sir, so this is the crux of the matter. If we go just a bit into that, when the law says preparation is an offense, that preparation has to be taken and understood by us as preparatory act punishable. Merely because preparation is used there, we should not read it as general theory preparation at the stage of the offense. By preparing to do that act of robbery or dacoity or waging war against the government, that act is complete, the offense is complete. So when you collect arms, when you collect funds and start an organization to achieve your object of toppling the government and start an agenda, programs like this, away from the democratic setup, sir, not within the democratic setup, those offenses, they are not to be read as preparations as we generally know. They are actually offensive acts. To prepare to do those things is an offensive act. Then, when the preparation is over, the guilty mind is formed, and the preparation is over. At that stage, the offender proceeds further to do the act. There two stages come, sir. Attempt and commission. As you all know, attempt, if unsuccessful, is an offense by itself. Attempt, if successful, becomes the main offense that is to be charged against him and tried. So this distinction is also there at the final stage. So as I just said, every offense has these clear stages. One must have clear idea. This is, in my understanding, the heart of criminal law. If you miss any part of it, you will be missing the main line of criminal law. Here I give you one example. The recently enacted, few years back, Negotiable Instrument Act is there. Just by giving a check in discharge of the existing debt and the check being dishonored, the man is punishable. So the act of giving check itself is made punishable there. There is no mens rea or guilty mind theory there. You have to answer why you have failed. That is why there, in that act also, a chance is given to pay back the amount within 15 days of receiving the notice or so. Strictly speaking, that is not a criminal offense, but it is conveniently made a criminal offense. That is a different part. So my instructions to you is that every offense has these changes. Some may be visible, some may not be visible. Unless you have got grip over this mens rea theory, which is also called as guilty mind, which is incorporated in every definition of the offense. the thing will not be complete for our understanding. Just I give you one example. One man or one person beats another person with a weapon. That person dies. If you just closely read this Bharatiya Nyaya Sanhita and understands the simple act of beating resulting in the death of that man will fall into number of offenses are not murder, as you all know. It starts from assault or using criminal force, then causing hurt by with a deadly weapon, then causing grievous hurt with a deadly weapon, then attempt to commit murder, then culpable homicide, not amounting to murder, then culpable homicide amounting to murder. Why? Why so many offenses? This single act resulting in the death of the person. Law is not straight away going to punish the offender for 302. Several aspects will be examined. What is the actual guilty mind of this man? Is it intending to cause death or knowing to cause such bodily injury as is likely to cause death, or knowing that by his act he is going to cause death? These clauses are there. The prosecution has to establish them, either one of those clauses. Then only he will be punishable for murder. Otherwise, even though there is death, the result is there as death, he may be punished for a lesser offense. So every criminal lawyer has to understand this distinction to bring down the offense from the gravity of murder into a lesser offense. There are good number of cases where the defense could establish that the intention of the person is only to cause a bodily injury only, nothing more. And that is punished, that was punished under 324 IPC. If a grievous hurt is caused, 326. Like this. Even if death is there, culpable homicide not amounting to murder under section 304 part 1 and 2 in the other Indian Penal Code, and in this Nyaya Samhita, it is 1 just because this act is new to me also, please excuse me. 105. 105 of the act. So every criminal lawyer should understand what is the actual mens rea element of the offense that is alleged against him, or that could be brought out in the case. If there are new members to the bar, just are deviating from the topic, I just suggest, excuse me if I am overstepping my limits. Don't always argue. My client is innocent, the case is false, the police filed a false case against me, against my client. We have to say, but while constructing the defense, you have to carefully construct the defense to, if you cannot get an acquittal, at least bring down the gravity of the offense. For that, you have to master this subject. Higher courts will definitely look into it. Unless you make the ground here for bringing down the gravity of the guilty mind, even the higher courts or the lawyers in the higher court can do anything, cannot do anything. So, sir, the trial court is a record-making court, as we all know. In the record, there must be circumstances and facts which bring down the correct guilty mind there. By getting a conviction, we don't lose the career. But by bringing in a difficult case, getting a lesser punishment to the client is also success. This I want to suggest to the younger people or new people who are to this field of criminal law. Don't hesitate. Be prepared to get a conviction. Here I may be permitted to add one more thing. As criminal lawyers, it is very good if we get acquittal in every case. If we can't get acquittal, what is it? Sir, criminal practitioners are there only to receive judgments of conviction and imprisonments. Civil lawyers won't get these types of judgments. Civil law only decrees will be passed, then execution will be there. Their journey is a bit safe. Here, the client will be there. నిన్నటి వరకు మనతో పాటు ఉన్నటువంటి వాడు గబాలన జైల్లోకి వెళ్ళిపోతుంటే ఆ జడ్జ్మెంట్ రోజు మనం వాడిని చూడలేము, వాడు మనం చూడలేడు. Still, have that satisfaction in your mind that I have conducted this case as a correct criminal lawyer. For this, sir, the study is required. To get acquittals, there are many ways. If witnesses don't support the prosecution, we get acquittal. But understanding the subject is the main thing, sir. For that, this guilty mind, which is required in every offense. In a 323, one type of guilty mind is necessary. In 325 or 326 IPC, one type of guilty mind is necessary. It is required. 307, one thing. 304, part 1, one thing. 304, part 2, another thing. And 302 is another thing. So I think I am making myself clear about this guilty mind aspect. Then, sir, there is a short theory in this guilty mind aspect. What is a guilty mind? How to decipher it? What the law requires on it is another subject. Basically, this mens rea has got 5 elements. All will not be there in the case, in every case, or in any offense. Intention, one thing. Knowledge is another thing. Reason to believe is the other phase of it. Rashness or negligence. These 5 aspects are there in mens rea. All these 5 aspects won't be there. Different offenses require different types of mens rea. Some offenses require intention to be punished, or knowledge to be punished, or reason to believe. Suppose in that 304A previously, which is now 106, section 106 in the Bharatiya Nyaya Sanhita, we call it as accident cases. When death is caused by a rash or negligent act, which does not amount to culpable homicide, it is punishable. But done with a rash or negligent act, it is punishable under the Bharatiya Nyaya Sanhita also. So the mens rea there, the guilty mind is rashness or negligence. It is not intention or knowledge. As you all know, if a person having enmity with another man takes his car and dashes against him intentionally to kill him, it is not a rash or negligent act. It is a deliberate act of killing the man. The weapon is there, the vehicle. So he will be punishable under 302 or 304 part 1 or 2, those are other things. He will be punishable first for the court will examine about culpable homicide, because his intention is very clear. Just we are going on the road, driving our vehicle, something happens and an accident occurs. We should not actually call it as accident, sir. An incident occurs, because accident has got its own definition in the general exceptions chapter. An incident occurs, the vehicle dashes against the man, and the man or woman happens to die with that injury. This is a rash act or a negligent act, as the case may be. When that is the situation, the guilty mind required is there as rashness or negligence. So, what is intention? What is rashness? What is knowledge? All these things, there may be a scope for some confusion. Actually, there need not be any confusion. One thing is, sir, briefly I touch these parts of the mens rea. First, let us take it as intention. Intention is understood as a determination of the mind to act in a particular manner. That is the fixed direction of the mind towards a particular object. I want to beat him, cause injury to him. My intention is that I take a stick and beat him on the head or somewhere and causes harm, injury to him. That is my intention. So that guilty mind, there is intention. In intention, there is no other thought in the mind of the offender except to achieve his object of causing that harm to the victim who is at his hands or near him. So this intention implies the capacity of the mind or to exercise one's will to do or not to do an act. Because act includes omission also. In a particular situation, law or the rules enjoin upon me to act in a particular way. I just omit to do it with an intention to cause harm to him. This is intention. Intention, it is said, the devil knows not the intention of a man. ఎవరికి తెలియదు అది ఇంటెన్షన్ అనేటటువంటిది. అయితే ఫ్యాక్ట్స్ అండ్ సర్కమ్స్టాన్సెస్ కేసులో ఉన్నటువంటి దాన్ని బట్టి వీడికి ఆ ఇంటెన్షన్ లేకపోతే ఈ పని చెయ్యడు, చేసి ఉండేవాడు కాదు, ఖచ్చితంగా ఆ ఇంటెన్షన్తోనే వీడి పని చేశాడు అని కనపడిపోతూ ఉంటాయి. We see several cases like that. It is a fact to be inferred. ఎవడు ఇంటెన్షన్ బయట పెట్టుకోడు కదండి. He will conceal it and do the act because his pleasure is achieving that object of seeing the man being injured at his hands. Then, stopping here for the time being, the next part of the guilty mind is knowledge. Knowledge is something, it is not intention. There is a clear distinction between intention and knowledge. Both are not one and the same. In the case where the offender has got the knowledge, here all these intention, knowledge or rashness, criminal negligence, all these things, criminal intention, criminal knowledge, criminal rashness, criminal negligence, like that you have to understand. Because we are discussing about the criminal law. Sir, it is defined in the textbooks. It is a state of mental realization in which the mind is a passive recipient of certain ideas and impressions arising in it and passing before it. It is a state of conscious awareness of certain facts in which human mind proceeds to commit the act, being fully aware of the consequences. I know fully well that the result is going to be that which is not wanted by others or by the victim. But I do it fully aware of that this is going to be the consequence. I may not intend it directly, but I do it. So intention and knowledge are two different aspects of the guilty mind aspect. These to be clearly understood. You may say, you may question me, when you have got the knowledge, when your mind has entertained the ideas and it has got the conscious awareness of the thing to follow or the result to ensue, still you have done means you intended to do it. But in several cases, in several instances, the accused may satisfy the court that it is not his intention. But your knowledge is there, you have not taken any steps to prevent that. That is one aspect, sir. So knowledge and intention are two separate things. A particular section may require one or the other. And these things are overlapping. The boundary line will not be clear always. But intention is something and knowledge is another thing. The next point is rashness. What is rashness? This is also something difficult to understand. In that section 106, rash or negligent act. That is how the section defines, even in 304A. It is not rash and negligent act actually. But in the other part of the section, it is said rash and negligent act. But in the old penal code, 1860 penal code, it is rash or negligent act. Because both are totally different terms, different states of mind. I am going on my car on a road at high speed. What for the motor vehicles are there, sir? Are they to go at a snail's pace, inch by inch, yard by yard? They are meant for going at a speed. But while driving them, you should take care of the situation and you should be able to stop the vehicle when it is going to cause harm to another. If you do not do it, means nothing will happen. Even if I go at 100 kmph speed on a very busy road like in Vijayawada, Bandar Road or something like that. If I go at high speed, what does it mean? Nowadays we see generally these youngsters seeing the cinemas, they go in snake-like drivings. Never apply brakes or never slow down the vehicle, but go between the vehicles and they go. Somewhere, if something happens, what should be done? What should be inferred from their conduct? In driving the vehicle like that, you have not taken any precautions, but you are under a hope. You are under an overconfidence that nothing will happen. I can drive it safely. Whatever be the strength of the thickness of the traffic, whatever the number of vehicles going there, I can drive it at 100 kmph. That is rashness. By mere speed, rashness cannot be concluded or inferred. For this, the definition is rashness is acting hastily without due consideration or regard for consequences. That means without taking proper care and caution for the clear and possible consequences, under the fond hope that evil consequences would not follow. నేను 20 ఏళ్ళ నుంచి డ్రైవ్ చేస్తున్నానయ్యా, ఎన్నిసార్లు వెళ్ళాను ఇట్లా, నా బండికి ఏమో కాదు. దట్ ఈస్ నాట్ ది సిచ్యుయేషన్. ఇన్ ఎవ్రీ ప్లేస్, if there is some obstruction or something that is going to happen, you have to foresee it and slow down or prevent that. You can't still, if you go hastily, it is rashness or rash act is an over hasty act. That will not be permitted by law. So this is also, they infer guilty mind there. When coming to negligence, then just a point more, it is running the risk. Rashness is running the risk of doing the act with recklessness, they say, or indifferences as to the consequences. You don't mind what is going to happen. You simply have the pleasure of going that speed. That is rashness. And then, sir, the other part is negligence. Negligence means it is the culpable neglect, not general negligence. Failure to take proper care and caution to prevent the untoward incident there. Suppose in a busy road, the vehicle is being driven, and this driver was talking over cell phone, diverting from the traffic, his attention from the traffic. And somebody comes across, or a vehicle comes across, or just comes before him. Your duty is to pay full attention to the traffic there. Every minute aspect there. You have to stop the vehicle. Because there is a divider, nobody should come. These defenses won't help in criminal cases. As you all know, contributory negligence is not a defense in criminal cases. Sir, so this is negligence. Rashness or negligence, criminal rashness or negligence that is required in cases like 106. While coming to that section, we can have some more talk on that. In the present 106, they have incorporated the failure of the doctors also, medical professionals also. That is a thing not for the present subject. Then, sir, the next item of mens rea is a reason to believe. What is reason to believe? If you just examine this clause reason to believe, it looks like knowledge. But it is not knowledge. Because the Sanhita itself, as well as the IPC itself, has defined reason to believe. Reason to believe is 29. Item number 29 in subsection in section 2 of the new Sanhita. A person is said to have reason to believe a thing if he has sufficient cause to believe that thing, but not otherwise. So, while doing the act, if the offender has got sufficient cause to believe that thing will happen, he has reason to believe. Here, it may appear to be like knowledge, but that is not knowledge. Knowledge is complete awareness of the fact, conscious awareness of the fact that that thing is going to happen and still I want to do it and I do it. That is knowledge. Here, with regard to reason to believe, it is said, it is not suspecting the possible event or doubting that that event may follow, that result may follow. This is not suspicion or doubt when it comes to reason to believe. It is something more. It is on a higher plane than these two aspects of suspicion and doubt. So, if you have got sufficient, the offender has got sufficient reason to believe, sufficient cause to believe, then he is said to act with reason to believe. These are only inferential facts from the case situation. This is by these things, intention, knowledge, rashness, negligence, and reason to believe, the guilty mind of a person will be assessed by the court or assessed by the statute in the first instance and make it punishable. Here, sir, just for your information, I want to give 13 items in section 2 of the Bharatiya Nyaya Samhita. Those 13 items are there in IPC also, which describe or throw light on this mens rea aspect. First thing is, if you want to note down, section 2, item number 7, dishonestly, that word is defined. That is equal to old section 24. Then item number 9, fraudulently, that is equal to old section 25. Then item number 11. Sir, if I am going too speed, please tell me, I will slow down. Can I? Item number 11, good faith. That is section 52 of IPC. Item number 29, reason to believe. This is section 26 of the IPC. Then item number 33, these are all of section 2. Section 2 lo items even in cheptunnatuvantivi. Item number 33 of section 2, voluntarily. This is section 39 in the IPC. Then Item number 36, wrongful gain, equal to section 23. Then item number 37, wrongful loss, equal to the same section, part 23. Then 38, gaining wrongfully and losing wrongfully. That is item number 38 of section 2, equal to the same section 23. So section 23 of the IPC is made into 3 items in this present Nyaya Sanhita. Then the group offences are there. 2 or more persons committing the offence. That is item number subsection 5 of section 3, equal to section 34, which is common intention. Then subsection 6 of section 3, equal to 35. Subsection 7 of section 3, equal to section 36. Effect caused partly by the act and partly by omission. Then item number, subsection number 8 of section 3, equal to section 37. Cooperating in doing one of the several acts constituting an offence. Then subsection 9 of section 3, equal to section 38. Liability for individual acts, though committed in a group, that person only will be held liable. These are 13 items, sir. They throw light on the guilty mind aspect of the theory or the offence concerned. About that, we'll come at a little bit later. Almost the same terminology and the same language is used or borrowed from IPC into these sections. The number of sections are reduced, probably, it seems. Then, one thing is, unless you have got clear grip over the meaning of these terms, you won't be understanding what is meant by mens rea clearly and understanding the nature of the offense that is alleged or you are going to defend in a case. Then, sir, I am further request one and all, don't be carried away by dictionary meanings of the words. To the experienced lawyers, I need not say this. To the newcomers, my request is, dictionary meanings are not legal meanings of the terms. They are only general meanings. In every enactment, whether it is a civil enactment or a criminal enactment, there will be definitions clause or that interpretation clause. Those definitions alone have to be understood, and those definitions alone have to be applied in that particular offense. So take care to understand them, and ordinary dictionaries are only just introduce us, open the doors for us to the subject. If you want to understand the clear meaning of it, go to the legal dictionaries. The meanings are given basing on the judgments and the other treatises and texts. They will give the meaning again in a clarified way. But the actual latest act, you have to understand. I think I have ran out of time. It is only 9:25. If you all permit me, shall I complete it? Shall I continue tomorrow? Please. Sir? Don't again.
Sir, any problem?
The time is already 9:25, it seems.
Oh,
That
yes, sir.
is why I am requesting my friends. whether
మాకు టైం తెలియలేదు సార్.
huh?
మేము టైం చూసుకోవట్లేదు.
నేను
తెలియలేదు
యాక్సిడెంట్
మాకు.
నేను యాక్సిడెంట్గా చూశాను.
సార్
సార్ shall I continue tomorrow?
ఎస్ సార్. 1 minute వీళ్ళని ఒక్కసారి అన్మ్యూట్ చేద్దాం. యు ఆర్ ఆల్ అన్మ్యూటెడ్ నౌ. మీరు ఒక్క నిమిషం మీరు ఏదైనా చెప్పండి.
Sir, good evening, sir.
Good evening.
Jaikar here, sir. It is not only a criminal.
జైకర్ వెయిట్. జైకర్ సార్ వెయిట్. ఈయన చెప్పాను కదా సార్, ఈయనకి ఖచ్చితంగా మీకు థ్యాంక్స్ చెప్తారు. కొంచెం గట్టిగా చెప్తారు.
Welcome, sir. Because the freedom is given to me to talk for long time.
Sir.
So I am talking.
Furthermore, don't exhaust because you have to conserve your energy for tomorrow, sir.
No problem, sir. No problem.
Sir, you are a third generation criminal lawyer. Hats off to you for your analysis. It is psychosomatic. Exact meaning analyzed truly from the psychological perspective of
Yes.
the mens rea, a criminal intent and a guilty mind. Exact example you have taken, rash and negligent driving, sir.
Yes.
So when we get a chance to practical applications or life application, can we ask any questions now or tomorrow we will reserve it?
You have
5 to 10 minutes I can spare.
Okay.
10
One quick
minutes.
question, sir. Quick question. I've been compromising criminal cases, but
Yes.
unless until an acquittal is called for as a judgment in the final culmination of the adjudication process, there is no compromise meaning at all, because it acts as a sword of Damocles sitting on the head of the accused.
Yes.
So,
Yes.
how one side, see, first of all, specifically to make the cut the story short,
Yes.
it is cheating as well as I deal in cyber crimes. As 67D, 67D is a cyber crime, and cheating is typical common man ordered online. So
Yes.
we have come to a stage where the accused is a criminal, convicted, meaning to be convicted, he wants to compromise. So I am trying to compromise, like using order 23 rule 3, but at the same time cheating, that is 420, cannot be a compounded offense. 67D as per IT Act, that is also cannot be compounded. So unless until the victim agrees to compound it, and it has to take a nod or an approval from the adjudicating court or a higher court, acquittal cannot be possible or compromise cannot be possible.
Yes.
But the point is acquittal is the end thing which closes the chapter. How do we go about it, sir?
Sir, one thing I tell you, strictly speaking,
Yes, sir.
in law, acquittal or conviction is not our concern.
Okay.
We have to do professional duty to the case.
Correct, sir.
There are several cases where acquittal is not possible.
Okay.
Suppose you and I are
Yes.
engaged previously to
Yes.
defend Kasab,
Yes.
who burnt the Bombay city,
Okay.
the lovely city of for Indians. The Bombay city was burnt by him and his companions. Several
Okay.
lives were lost, but you and I are defending him. There we have to do our duty. The flaws in investigation, the aspects which are favorable to him have to be brought to the notice of the court, and the ultimate result we have to leave to the court. We should not think of acquittal always. The manner of conducting the defense, the manner of cross-examining the witnesses, the manner of setting up the defense, these things are important for us. That is why your question is good, sir. But nowadays, what is happening is every client demands an acquittal from us, through us.
Correct.
There we have to exercise some control over the client, except that there is no go for us.
Okay, sir.
Because we are not writing the judgment.
Yes, sir.
The judge is writing the judgment.
Obviously, sir.
So we have to leave it to the judge by performing to the best of our ability there. For that, your weapon is only preparation, cross-examination, and arguing the case as per the decided case law.
Okay, sir. Thank you very much, sir.
Thank you. God bless you, sir.
సార్ నమస్తే సార్.
నమస్తే.
సుప్రీంకోర్టు 2006 సైటేషన్ ఒకటి చెప్పారు, అది కొంచెం మళ్ళీ రిపీట్ చేయగలరా?
2006. Sure, చెప్తానండి 1 minute లో.
Actually, this session is a live streaming. ఒకవేళ సార్కి రీకలెక్ట్ చేసుకోపోయి లేకపోయినా మనం అక్కడ ఒకసారి వెరిఫై చేసుకోవచ్చు.
1 minute లో చెప్పేస్తాను. It is ready because friend has asked. No problem. 2006 సార్ ఒకసారి చేయొద్దండి. ఎవరు సార్ అడిగిన చేయొద్దండి సార్.
కృష్ణ గారు, వైవిఎన్ కృష్ణ గారు.
ఓకే సార్. 2006-2
yes sir.
SCC criminal.
Okay.
Page 221. Para 29.
Okay sir. Okay, thank you sir.
చాలా చక్కగా, చాలా సార్ లాంగ్వేజ్ కూడా బాగుందండి దాంట్లో. ఒకసారి చదవండి ఆల్ ఆఫ్ ఇంతకుముందు చదివి ఉండకపోతే
వినిపించండి
అండి.
అది మాకు కూడా వినిపించండి అంటున్నా.
అట్లాగా, ఓకే.
యాక్చువల్లీ ఇంకా ఇద్దరు హ్యాండ్స్ రేజ్ చేశారు.
చెప్పండి సార్. పర్వాలేదు.
Thank you, Guru Garu. Just for that one word I want to say. Thank you very much.
Okay, right.
Your good name?
I am Ram Prasad. Bezodabar.
Yes, sir. Thank you, sir.
Madam, thank you very much for conducting this session. We are so grateful to you.
No thanks, no sorry. Only thing and మీ వైపు నుంచి కాంట్రిబ్యూషన్ ఏంటి, మీరు ఏ సబ్జెక్ట్ చెప్తారు, లేకపోతే ఏ సబ్జెక్ట్ అన్నా ఇలా ఎంతూజియాస్టిక్ గా వింటారా, ఈ 2 రోల్స్ లో యూ మస్ట్ బి దేర్ అన్నమాట.
I am from Vijayanagaram bar, madam.
విజయనగరం. వెరీ గుడ్.
ఇది ఒకళ్ళు నలుగురిని పరిచయం చేయాలన్నమాట. ఐ విల్ ఇంట్రడ్యూస్ వన్ గై సార్. ఇక్కడ నరసింహారావు గారని మనకి మొన్న లిమిటేషన్ యాక్ట్ చెప్పారు. వైఎన్ఆర్ గారు లిమిటేషన్ యాక్ట్ కంప్లీట్ చేశారు. ఉన్నారు సార్.
సార్ ప్లీజ్.
నమస్తే రామచంద్ర గారు.
నమస్తే అండి.
ఇంట్రడక్షన్ చాలా బాగుంది.
అయితే
ఇవాళ ఇంకా క్వశ్చన్ స్టేజ్ దాకా మనం వెళ్ళకుండా ఉంటే బాగుంటుంది అనిపించింది నాకు.
ఏంటి సార్ 2 hours?
అలాగే అపీల్ టు ఫ్రెండ్స్ ఆల్సో మీరు ఐపీసీ సబ్స్టాంటివ్ సైడ్ డీల్ చేస్తున్నప్పుడు ప్రొసీజరల్ సైడ్ క్వశ్చన్స్ రాకుండా ఉంటే బాగుంటుంది. సిఆర్పిసి లో తెలియకుండా వెళ్తున్నాం, ఇంటర్ రిలేటెడ్ సబ్జెక్ట్స్ కదా. క్వశ్చన్ లో మీ ఎక్స్పెడిషన్ కాదు, ఎక్స్పెడిషన్ ఇస్ వెరీ ఎక్సలెంట్.
థ్యాంక్ యూ. అంటే
ఎలిమెంట్స్ మీద స్టూడెంట్స్ ఎలా చెప్పాలో అలా చెప్పారు.
అంటే మై ఇంటెన్షన్ is, sir, it is an exercise to me now through the courtesy of madam, and the other thing is by exchanging my view with you, friends will put questions. I may have to correct myself sometimes.
అంటే ఎలైట్ క్వశ్చన్స్ ఎలాగా మనం ఆన్సర్ చేయాలి, సో దట్ దే విల్ బి ఎలైటెడ్. కాకపోతే అట్ ది సేమ్ టైం మనం ఒక్కసారి వచ్చి చెప్తే సటిల్ డిఫరెన్స్ కదండి ప్రొసీజర్ కి సబ్స్టాంటివ్ కి.
ప్రొసీజర్ ఇస్ డిఫరెంట్. ప్రొసీజర్ ఇస్ యాక్చువల్లీ డిఫరెంట్.
మేము మిమ్మల్ని మీ స్పీచ్ లో మేము మిమ్మల్ని అడిగినప్పుడు ప్రొసీజర్ లకు వెళ్లకుండా సబ్స్టాంటివ్ సైడ్ అడిగితే అదర్ ఫ్రెండ్స్ బాగా గ్రేట్ అవుతారు అని. అంటే ఇంట్రడక్టరీ పార్ట్ చాలా నీట్ గా చెప్పారు. ఎలిమెంట్స్ లో పిల్లలకి ఎంతవరకు వెళ్ళాలో అంతవరకు. అసలు ఇవాళ మినిస్ట్రీ అండ్ సిటరీ అంటే ఎవరికి తెలియదు.
బికాజ్ నవేడేస్ కొంచెం ఎందుకు ఆ సబ్జెక్ట్ మీద సీరియస్నెస్ తగ్గింది సార్. We don't know, but we have to bring it up. No problem. People will understand it. Yes, sir. Any more questions, sir?
మీరు చెప్పిన ఇంటెన్షనల్ నాలెడ్జ్ డిఫరెన్స్ మళ్ళీ కల్పలం సైడ్ దగ్గర వస్తుంది. అప్పుడు వీళ్ళందరికీ మంచి ఎక్స్ప్రెషన్ వస్తుంది. ఎందుకంటే అది చాలా హైలైటెడ్ ఎక్స్ప్రెషన్ అక్కడ ఆ చేంజ్. ఇవాళ మీరు ఒక టార్ట్ క్వశ్చన్ చెప్పారని వీళ్ళు అనుకుని ప్రిపేర్ అయి ఉంటే మీరు ఆ సెక్షన్ చెప్పినాడు వాళ్ళకి చాలా ఎలాబొరేషన్ వస్తుంది అక్కడ. అంటే ఇది జూనియర్స్ కండి నేను చెప్పేది, సీనియర్స్ చెప్పకూడదు, జూనియర్స్ అందరికీ. అది ఇందాక మీరు ఇంకొక హింట్ ఇచ్చారు, క్రాస్ ఎగ్జామినేషన్ చాలా జాగ్రత్తగా చెయ్యాలి అని. 162లో కనిపించింది అని కాంట్రడిక్షన్ కి వెళ్ళిపోతే అది గ్రేవ్ ఆఫ్ బెనిఫిషియల్ వాళ్ళు చూసుకోవాలి.
అది యాక్చువల్గా క్రాస్ ఎగ్జామినేషన్ ఒక ఆర్ట్ అండి, అది కొంచెం అబ్జర్వ్ చేయాలి అండ్
చాలా ఓన్లీ బై పర్సెప్షన్ అండి, నో అదర్ మీన్స్.
మై ఫాదర్ యూజ్ టు టెల్ మీ, ఇఫ్ యూ డూ నాట్ నో, డోంట్ క్రాస్ ఎగ్జామిన్. At least on some technical point, the advocate in the higher court will struggle himself and get the client out. If you cross-examine an unnecessary aspects and fix your client with all cementing things, even the most intelligent advocate in the higher courts cannot get him out. His fate will be sealed once for all. So when we can't put our foot correctly to that aspect,
చాలా సూసైడల్ అయిపోతుంది అప్పుడు.
we don't put those questions or don't touch that aspect. That what he told me. In some other angle, the intelligent advocate will cover it in the appeal. And one thing one word, Ram Jethmalani in an interview said, the art of cross-examination is dead now in India అన్నాడు. ఒక వీడియో కూడా ఉందండి, మీరు ఎవరైనా చూస్తే చూడండి యూట్యూబ్లో. ఆయన ఎన్ని రకాల అపీల్స్ చూసి ఆ మాట అన్నాడో మరి మనకు తెలీదు. అందుకని ఇట్ అవేకెన్ సమ్ డిజైర్ ఇన్ అవర్ మైండ్స్ నౌ టు వర్క్ ఫర్ దట్ పర్పస్. ఆయన అన్నాడని కాదు, వీ హ్యావ్ టు స్ట్రగల్, వీ హ్యావ్ టు పుట్ ప్రాక్టీస్ ఇన్ టు ఇట్ అండ్ డూ ఇట్. వన్ లాస్ట్ వర్డ్ సార్, ఇన్ అవర్ కాలేజ్ డేస్ వన్ లెక్చరర్ యూజ్ టు సే, టర్న్ ద పేజ్ అండ్ లెర్న్ ద వర్క్. Just by hearing the lectures or from some others, we don't learn the subject as it is. At the depth of the subject, we can never learn. It is you who have to go through the pages. And my father used to tell me, ప్రతి సెక్షన్ ని నవలాలట, నవిలి దాంట్లో ఉన్నటువంటి సారాన్ని గ్రహించాలట. చెరుకు గడ్డను పట్టుకుని
డైజెస్ట్ అయిపోవాలి.
చెరుకు గడ్డను పట్టుకుని నవిలితే దాంట్లో ఉన్న సారాన్ని మింగి పైన ఉన్నటువంటి తొక్కను బయట పారేస్తాం ఆ పిప్పిని. ఆ పిప్పి ఏంటంటే ఫస్ట్ డే మనకు వచ్చినటువంటి అండర్స్టాండింగ్ అది సబ్జెక్ట్. అది ఓన్లీ ప్రిలిమినరీ. పోగా 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 షార్పెన్ అవుతుంది. ఆ నాలెడ్జ్ని మనం ఇంబైబ్ చేసుకోవాలి. ఐ డిడ్ a few % of it. I request that each one of you will do well in that.
సార్ ఎవరి వీడియో సార్ మీరు చూడమన్నారు క్రాస్ ఎగ్జామినేషన్ దాని గురించి?
థ్యాంక్ యూ సార్, చాలా బాగుంది.
రామ్ జెత్మలాని ఊరికి కామెంట్స్ చేశాడు ఆయన. ఆర్ట్ ఆఫ్ క్రాస్ ఎగ్జామినేషన్ ఇస్ డెడ్ ఇన్ ఇండియా అన్నాడు ఒక పెద్ద మాట. అంటే ఏంటంటే లోయర్ కోర్సు సరి క్రాస్ చేయటం లేదు అని కదా. ఇవాళ రోజు అసలు కంటెస్ట్ కేసులే ఉంటుందా
సార్? ట్రయల్ కోర్టులోని క్రాస్ చేద్దామన్నా కూడా ఆఫీసర్స్ అవసరం లేదు, ప్రొసీడ్ నెక్స్ట్ అంటున్నారు తప్ప స్కోప్ ఇవ్వట్లేదు సార్.
అది చాలా అన్ఫార్చునేట్ సిచ్యుయేషన్ అండి. మనం ఏదో ఒక రకంగా దాన్ని ఇంకొక ఆస్పెక్ట్లో ఒక విట్నెస్ని కొంత చేసుకుంటూ వెళ్ళాల్సిన పరిస్థితులు వస్తున్నాయి సార్.
అండ్ మోర్ ఓవర్ సార్, ఆఫీసర్స్ ఎట్లా ఉన్నారంటే ఈ ఐఓస్ ని మనము క్రాస్ చేస్తున్నప్పుడు కూడా వాళ్ళు అబ్జెక్ట్ చేసేస్తున్నారండి. ఐఓకి తెలుసు అన్ని, అట్లా కొంచెం ఇబ్బందికరంగా ఉంటుంది సార్.
ఇక్కడ ఒక ఆస్పెక్ట్ సార్ నేను చెప్పగలిగింది ఏంటంటే, ప్రాక్టీస్ ఆస్పెక్ట్లో సపోజ్ దట్ ఈస్ అ వైటల్ క్వశ్చన్ అండ్ యూ కాంట్ లీవ్ ఇట్, బట్ ది ఆఫీసర్ ఈస్ నాట్ పర్మిటింగ్, ఆస్క్ దెమ్ టు రికార్డ్ దట్ క్వశ్చన్ అండ్ డిజలవ్ ఇట్.
ఎస్ సార్.
ఎందుకంటే హైకోర్టుకి వెళ్ళినప్పుడు ఆ అడ్వకేటు ఏం చేశాడే మీ ప్లేడర్ అంటాడు. నిజంగా ఏం కనపడదు అక్కడ. ఈ జరిగిన సిచ్యుయేషన్ వాళ్ళకి తెలియదు.
ఎగ్జాక్ట్లీ సార్.
సో ఇన్ ఏ గివెన్ సిచ్యుయేషన్ ఇఫ్ ఇట్ ఈస్ సో ఇంపార్టెంట్, అయితే రోజు కోర్టు తగాద పెట్టుకుని మనం రన్ కాలేం.
ఎగ్జాక్ట్.
ప్రొఫెషన్లో. ఆ సిచ్యువేషన్ ఏంటంటే నా ప్రశ్న రాసి రిజర్వ్ చేసేయండి పర్వాలేదు అంటవి. అక్కడ మాత్రం కొంచెం ధైర్యం చేయాల్సిందే మీరు. ఇఫ్ దట్ సిచ్యువేషన్ ఇస్ దేర్. ఓకే సార్.
సో కైండ్ ఆఫ్ యూ సార్.
Sir, thank you
Have
very
a
much.
great night, sir.
I feel that each one of you has spent your valuable time listening to my this thing.
Actually,
It's our
ఈ క్లాస్
pleasure.
highest
more
reach
fortunate enough, sir.
అమ్మా ఏం లేదమ్మా, ఇంకా చాలా ఉంది దీంట్లో. నేను జస్ట్ చెప్పింది సూపర్ఫిషియల్ గానే, అంతా చెప్పలేను.
demand on the subject interest గాని there is more, sir. Nearly 235 members they have joined.
Thank you.
highest అన్నమాట.
Thank you for mobilizing them and for each one of them for showing the interest to join.
Actually, I need to thank another two people. One Jaikar sir and Prasad garu. Prasad babu garu. నేను ఒక రిక్వెస్ట్ అడగగానే జైకర్ గారు మీ పేరు గుర్తొచ్చింది. అంటే యూఆర్ గుడ్ రీడర్ అనేది, ఒక ఆరేటర్ అనేది సారు గ్రహించారు. అది ప్రసాద్ బాబు గారు ఇక్కడే ఉన్నారు. ప్రసాద్ బాబు గారు చెప్తే దెన్ ప్రసాద్ బాబు గారు నన్ను మీ దగ్గరికి తీసుకొచ్చారు. అంటే వెతగ్గా అనిముత్యాలు దొరుకుతున్నాయి. అంటే చుట్టుపక్కల కూడా చాలా మంది ఉంటారు. యూ ప్లీజ్ లెట్ మీ నో, then we will call them to our session and we will learn many things from them. Okay. And I request my friend Haribabu garu to vote of thanks, give his vote of thanks.
సార్, మీ ఇంటి పేరు దిట్టకవి అనగానే మీ పూర్వీకులు ఎవరో కవిత్వంలో మంచి దిట్ట అయి ఉంటారని అనుకున్నాం. కాదు,
మేమండి చెట్టు పేరు చెప్పుకుని పూలు అమ్ముకునే వాళ్ళం.
కాదు మీరు ఇప్పుడు ఈ క్లాస్ విన్న తర్వాత మీకు ఈ క్లాస్ విన్న తర్వాత మీకు లాభం ఇవ్వాలి ఆ దిట్ట అనేది. నిజంగా చాలా బాగా చెప్పారు. అంటే జనరంజకంగా ఉంది, అందరికి బాగా ఆకట్టుకునేలాగా చెప్పారు. రేపటి నుంచి
to be frank, it is the bhiksha taken from my gurus.
Yes, sir.
That which I am just trying to spread.
అంటే దానివల్ల ఆ గురు పరంపర వలన వాళ్ళందరూ కూడా ఇంకా మీ నాలుగు మీద జీవించే ఉన్నారు. అందరికి మేమందరం రుణపడి ఉన్నామండి. అందరి తరఫున వన్స్ అగైన్ థ్యాంక్ యూ సార్. థ్యాంక్ యూ.
We'll continue tomorrow, sir.
మళ్ళీ రేపటి మీ క్లాస్ కోసం వెయిట్ చేస్తూ ఉంటాం.
Thank you one and all.
Thank you, sir.
Okay, sir.
Thank you, sir.
Thank you, ma.
Thank you, sir.
Thank you.
Thank you, sir. And
Thank you.
Thank you so much, sir.